Supreme Court Judge Gorsuch blasts the pandemic, a lot of other government overreach, as being the greatest intrusion into American civil liberties in history. We're going to take a look at the opinion that came out from the Supreme Court. But first, let's get some background on this over from the news. They tell us that the intrusions the Supreme Court dismisses or talks about come after Title 42 is dismissed, at least in the Supreme Court on this claim. On Thursday, the Supreme Court dismissed an appeal challenging the end of Title 42. The move was widely expected, but the opinion from Judge Gorsuch was not. The court had already stricken the case from the argument calendar, but Judge Gorsuch wrote a spicy opinion here. The Supreme Court in December initially agreed to hear the challenge from conservative states, but the underlying case appeared to evaporate when the administration lifted the public health emergency. The Supreme Court wrote a single paragraph order. It was unsigned. It was not clear how each judge voted. Ketanji Brown said she would have dismissed the case, but Judge Gorsuch gave us a little bit more details on it, and it was quite satisfying. So let's take a look at it. The case is Arizona versus Alejandro Mayorkas, and it's a very short statement here. You can see we're basically done. On December 16th, the order of the United States Court of Appeals denying the motion to intervene is vacated. This whole thing is moot, right? Now, this is where Judge Gorsuch comes in. He says, this case concerns Title 42. Those emergency decrees that came out, like Title 42, severely restricted immigration in this country for the ostensible purpose of preventing the spread of COVID. The federal government began issuing the orders March 2022, continued issuing them until April 2022, when those officials decided it was no longer necessary. If that seems reasonable enough, okay, events took a turn. In a federal district court in Louisiana, Gorsuch says a number of states argued that the government's decision to end Title 42 violated the law because agency officials had not provided advance notice of their decision. The states did not seriously dispute that the public health justification had lapsed. The states also understood their lawsuits would only require the government to take certain additional steps, but the states apparently calculated that even a short court-ordered extension of those decrees was worth the fight. The state wanted these powers extended. Worth it because in their judgment, a new and different crisis had emerged at the border, and the federal government had done too little to address it. So keeping the Title 42 orders in place, even temporarily, was better than the alternative. In the end, the district court agreed with the states, entered a nationwide injunction that effectively required the government to enforce Title 42 until something else happened. Meanwhile, Gorsuch says 1,000 miles away, a group of asylum seekers submitted a competing class action lawsuit in D.C. This group argued that from the start, the government lacked legal authority to even issue Title 42. And so ultimately, the D.C. court agreed with the group's assessment and issued equally sweeping forms of relief and so on. And so the judge is saying, my goodness, if these head-spinning developments were not enough, even more followed. Displeased with the D.C. court, some states in Louisiana moved to intervene. And now, almost 5 months later, the court puts a final twist in its tail. It vacates the appellate court's order denying the state's motion to intervene and remands. But why the about face? Recently, Congress passed and the president signed into law a declaration saying COVID is over. The Secretary of Human Services, too, has issued his own directive. Apparently, these developments are enough to persuade the court that Title 42 orders the government wished to withdraw a year ago are now moot. Long story here, but he says, I recite all of this tortured procedural history, not because I think today's decision is wrong. Nearly 5 months ago, I argued that the court erred when it granted expedited review and issued a stay. As I explained then, I do not discount the state's concerns about the border, but the border crisis is not a COVID crisis. And this court took a serious misstep when it effectively allowed non-parties to this case to manipulate our docket to prolong an emergency decree designed for one crisis in order to address an entirely different one. You gave permission for Title 42 for COVID, not for the border. Now, I lay out that history only because it's so typical, not just as an illustration of the quandaries that can follow when the district courts award national relief, but even more importantly, the history of this case illustrates the disruption we have experienced over the last 3 years and how our laws are made and how our freedoms are observed. Here we go. Since March 2020, says Gorsuch, we may have experienced the greatest intrusions on civil liberties in the peacetime history of this country. I couldn't agree more with that statement. Executive officials across the country issued emergency decrees on a breathtaking scale. Governors and local leaders imposed lockdown orders, forcing people to remain in their homes. They shuttered businesses and schools, public and private. They closed churches, even as they allowed casinos and other favored businesses to carry it on. They threatened violators, not just with civil penalties, but with criminal sanctions too. They surveilled church parking lots, recorded license plates, issued notices warning that attendance at outdoors events satisfying all state social distancing and hygiene requirements could amount to criminal conduct. They divided cities and neighborhoods into color-coded zones. They forced individuals to fight for their freedoms in court on emergency timetables, and then they changed their color-coded schemes when defeat in court seemed imminent. Federal executive officials entered the act too, not just with emergency immigration decrees. They deployed public health agency to regulate landlord-tenant relations nationwide. They're our houses now. They use workplace safety agency to issue vaccination mandates for most working Americans. They threatened to fire non-compliant employees, and they warned that service members who refuse to vaccinate might face dishonorable discharge and confinement. These disgusting monsters. Along the way, it seems federal officials may have pressured social media companies to suppress information about pandemic policies which they disagreed with. And while executive officials issued new emergency decrees at a furious pace, state legislatures and Congress, the bodies normally responsible for adopting our laws, too often fell silent like little weenies. Courts bound to protect our liberties addressed a few, but hardly all of them, of the intrusions. They bent over backwards. Everybody collapsed like cowards. In some cases like this one, courts even allowed themselves to be used to perpetuate the emergency public health degrees for collateral purposes. They made emergency lawmaking by litigation. Exactly right. The courts just said, well, we're in charge now. It's an emergency, so we're going to do these things. Doubtless, many lessons can be learned from this chapter in our history, and hopefully serious efforts will be made to study it. One lesson, says Gorsuch, might be this. Fear and the desire for safety are powerful forces. They can lead to a clamor for action, almost any action, as long as someone does something to address a perceived threat. As long as you make me feel safe, you can do whatever you want. A leader or an expert who claims he can fix everything, if only we can do exactly as he says, can prove an irresistible force. We do not need to confront a bayonet. We only need a nudge before we will willingly abandon the nicety of requiring laws to be adopted by our legislative representatives and accept rule by decree. Along the way, we will accede to the loss of many cherished civil liberties, the right to worship freely, to debate public policy without censorship, to gain with and gather with friends and family, or to simply even leave our homes. We may even cheer on those who ask us to disregard our normal lawmaking processes and forfeit our personal freedoms. They're fighting for us. They're keeping us safe. Fauci, Fauci, Fauci. Of course, this is no new story. Even the ancients warned that democracies can denigrate towards autocracy in the face of fear. But we may have learned another lesson too. The concentration of power in the hands of so few may be efficient and sometimes popular, not for me, but it does not tend towards sound government. However wise one person or advisors may be, there is no substitute for the wisdom of the whole of the American people that can be tapped into the legislative process. Decisions produced by those who indulge no criticism, like the CDC, like the follow the science people. We're scientists, you're not. You can't criticize us. They are rarely as good as those produced after a robust and uncensored debate. The tinkerers beat the academics every single time. Decisions announced on the fly are rarely as wise as those that come after careful deliberation. Decisions made by a few often yield unintended consequences that may be avoided when more are consulted. Autocracies have always suffered these defects. Maybe, hopefully, we have relearned these lessons too. Many of us have their Justice Gorsuch. I'm not sure about a lot of others though. In the 1970s, Congress studied the use of emergency decrees. It observed that they can allow executive authorities to tap into extraordinary powers. Congress also observed the emergency decrees have a habit of long outliving the crises that generate them. The federal emergency proclamations, Congress has noted, had remained in effect for years or decades after the emergency. And so we have to balance these considerations and ensure a more normal operation of our laws and a firmer protection of our liberties. But despite various laws, the number of declared emergencies has only grown, and it's not hard to wonder whether, after nearly a half century and in light of our nation's recent experience, another look is warranted at protecting us and protecting the citizens from government emergency power. It is hard not to wonder too whether state legislatures might profitably re-examine the proper scope of emergency powers at the state level. At the very least, one can hope that the judiciary, the judges, will not soon again allow itself to be a part of the problem by permitting litigants to manipulate our docket to perpetuate a decree designed for one emergency to address another. Make no mistake, decisive executive action is sometimes necessary and appropriate, but if emergency decrees promise to solve some problems, they threaten to generate others, and rule by indefinite emergency edict risks leaving us all with a shell of a democracy and civil liberties just as hollow. Judge Gorsuch, United States Supreme Court. All these whiners on the left crying about wrecking our democracy when they don't adhere to any of the civil liberties or care about them at all. They say you should be locked in your home, you should be forced to take a jab or lose your job or be thrown out of the military, lose your property rights, your personal autonomy, your personal freedom, all in the name of science. Put your mask on, take the jab, lock yourself up, shut your mouth, do what Fauci says. And then they turn around and scream at us that this is all necessary to protect democracy as they crap all over the liberties that created this democracy, this democratic republic in which we live or lived. So these people absolutely rightfully blasted by Judge Gorsuch. One of the better things we've ever read here and absolutely satisfying. I couldn't agree more. The biggest peacetime intrusion on our civil liberties in American history. And the question will be, how do we stop this from ever happening again?